Hello, and welcome to the Three Questions podcast, where we dive deep into the world of wealth management and connect you with industry experts. I'm your host, Wayne Baxter, Senior Executive Manager at One Capital Management. Are you or someone close to you a Canadian who is considering relocating to the United States? If so, you definitely do not want to miss today's episode. We're going to address the three questions Canadians should ask about estate planning when relocating to the United States. Thank you for taking time to check us out. And if you enjoy this episode of the Three Questions podcast, please consider liking this video and subscribing to our podcast and YouTube channels. On today's episode, we're going to explain the world of U.S.-Canadian cross-border estate planning and addressing the three questions Canadians should ask about estate planning when relocating to the U.S. Joining me from Portland, Oregon is Carolyn Bys. She is an attorney at Goodwill and Trust Estate Planning Law. And Carolyn assists business owners and real estate investors to protect theirs and their family's assets through estate planning. And Carolyn has a special niche in working with U.S. expats abroad and non-U.S. citizens here in the U.S. on cross-border estate planning. And that's backed by her international expertise. So, Carolyn, great to see you. We finally made it. Get you on the podcast. Great to see you.
Thanks, Wayne. Happy to be here.
Yeah, it's going to be fun. I've been looking forward to this conversation. Now, I'll say this right off the bat, and part of my motivation for having you as a guest is that you have a very, very, very interesting background. You've practiced law at The Hague in the Netherlands, in Warsaw, Poland. You've advised U.S.-based companies all over, I guess, Europe. Like, how did these roles, I guess, first of all, you can give us a little background on your roles over in The Hague and in Warsaw, but how did all of these roles lead you to become a cross-border estate planning attorney? Really
Yeah,
interesting.
great question, Wayne. So for nearly a decade, I lived, like you say, a very international life, both professionally and personally. I spent about half that time living in Europe, where personally I learned how difficult it was to be an expat navigating local jurisdictions and how important it was to have someone local be able to explain things to me. Professionally, I had an interesting career where I did a lot of comparative law in different areas. So that required understanding different legal jurisdictions and systems than my own that I had been practicing in for years. First, I trained prosecutors and law enforcement across Eastern Europe on investigating hate crime. Next, I worked in the general counsel's office of a large US headquartered international nonprofit where I helped establish and lead their first ethics and investigations unit, where I oversaw workplace misconduct in 40 countries around the globe. So that included fraud, corruption, sexual harassment, and navigating labor law in many different jurisdictions. And then COVID hit. As probably many of your listeners have a story to tell, I have my own about a transition story. Not only was I looking to move out of that constant international travel, but I had an awakening to move out of reactive, crisis driven law. And that's when I got myself trained up in estate planning law. And who knew death and taxes would be my sweet spot? And
Definitely.
yeah. And while I didn't love the constant travel I was in my last position, I do have ambitions of returning to that expat life, but this time on my own terms. And it
I gotta
also
ask
made
you a
me
question.
realize, yeah,
I hate to interrupt
sure,
you. I gotta,
sure.
my brain works too fast, and I apologize for interrupting.
No, that's
But-
okay.
So during your time in Eastern Europe, did you ever make it to the Ukraine?
Yes, I did.
Kiev?
Yes, I even was in Crimea as well.
Wow, really? Was this after
Yeah.
post 2014 or
No, pre
after? Okay.
2014.
Okay.
Yeah. So around actually not that
Wow.
far before that, 2012.
Wow, what a
Yeah.
story. So
Yeah. Yeah.
how did you enjoy your time in Warsaw?
Winters were tough, but I'm speaking to Canadians, so I shouldn't complain about winters too much. Um,
Well, I
but
can identify with
otherwise,
that.
yeah,
And
otherwise life was good. Food was wonderful. People were lovely. Just I really did enjoy my time there. Yeah.
I have a client of mine whose son actually is currently living in Krakow. And
Ah.
and loves it there. Loves it there.
Yeah.
Interesting story. I swear, I just couldn't help myself. I apologize. I know we got a
Ah,
lot
no,
to
that's
cover.
okay.
So
That's okay. This is
if
what
I
this is
wrecked your
all
train of,
about.
if I wrecked your train of thought,
Absolutely
shame
not.
on.
Absolutely not. But
So that's
it
really
was,
cool. I thought it was so
ah,
fascinating when I first met you that
yeah,
you had lived abroad and actually, didn't just visit there, but you were like in the trenches.
correct. Correct.
So COVID kind of hit through a curveballs, but that's where we were before I really interrupted you.
Yeah, yeah. So I mean, COVID had me traveling all over the world at that point. Middle East, Africa, Asia, all within the scope of a couple months. And from Portland, it's going every direction. And that's when I decided I needed to get out of it and do something different. And at the same time, I remember thinking, how am I going to, pitch myself? I have this wonderful international background. How does that work with estate planning law? And then the light bulb went off. It made me realize that I have a unique background and experience to bring to estate planning, both the understanding and the aptitude for cross jurisdictional work, and a good network already of international contacts to help me coordinate holistic estate plans that can cross borders. I'm never going to be a sole individual when we're talking about assets and lifestyles that span multiple countries, but I am going to find you the right people in the other countries to be part of your team. Um,
Interesting. Okay, I got a question on that note.
sure.
So I get approached by people, not just Canadians, right? I get approached by people in different parts of the world who are either looking to move there or are from there, not just Canada,
Hmm.
India, for example, or different countries in Europe, like some of the places that you've been already. So, are you able to, if they were to say, listen, I'm going to end up with assets in the United States or Canada, maybe, for example, they may have lived in the US for like, say, 25, 30 years, and they've accumulated, a decent sized, IRA and a revocable trust, but now they want to move to France or they want to move to
Hmm.
India. Like, are those cases that you can actually collaborate on? And
Oh, yeah, absolutely. To date, I've worked with clients with ties to Canada, Mexico, UK, Australia, Japan, South Korea, and Brazil. Coming up next on my plate are Belize, China, uh, uh, and Germany, and also France. I've done a lot of work with France as well. So, yeah, and I also work with clients who span more than one country, which can always be interesting.
oh
Yeah,
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 well,
yeah.
this is really important to know because I do come across these cases. That's why I love having resources like you that I can rely on. So recently, I was a guest speaker on a roundtable where the topic was about Canadians relocating to Florida, and I outlined the key financial steps that are, I believe, crucial for successful relocation. And I will say that, I was the for that experience in my orbit, I was the canary in the coal mine. So I fortunately had some really good advisors to help me, but still there were, I would say, some things that if I had a chance to do it over, I would probably do differently.
Hmm.
Uh, to be clear, above and beyond the financial steps, which I kind of focused on, there are also some crucial estate planning related steps that need to be considered. And Carolyn, I guess the first question I would ask you for someone who's looking at that relocation idea, strategy, when would you suggest that a family actually start the strategizing? What's the lead time, if you will?
Yeah, that's a good question. It's never too early to begin strategizing and getting some consultation advice if you're considering relocating to include your estate plan in that, because the information you may find out may impact your ultimate decisions of what you do strategically with your finances in terms of where you structure them and what you do. For example, just yesterday I had a consultation with a couple who this weekend are planning their trip to France to do some reconnaissance work to find their dream house in France. But they wanted to meet with me first to get a better understanding of what estate planning would look like in the future. Um, and sometimes when people are moving into the US, depending upon your income, your business, your family dynamics, there can be some things that we might want to do before you even move here. I'm the type of attorney that I love a proactive client. I hate telling a client, well, if you had come to me earlier, there are other
Oh,
techniques we could
yeah.
have
Where
used.
were you 6 months ago, right?
Right, right. My practice is built on relationships, not transactions. So I would prefer to do
Likewise.
what's
Yeah.
best for the client, even if it's months or years down the road.
I just want to mention one more thing before we move on to our questions. I mentioned at the round table that I appeared on, so some shameless self-promotion here, Carolyn. Apologies. Uh, you can actually find the recording of that roundtable on the Three Questions website. And if you go to the website and scroll down to the bottom of the page, there's a section called guest appearances. And my appearance on I think it's called the Miami Gardens Chamber of Commerce. You can see the full episode, including my points that I addressed. So I would encourage you to check out the website as well. Okay, let's get right to the three questions. No reason to delay any further. And again, these are the three questions that Canadians should ask, estate planning questions they should ask before relocating to the US. So let's start with number one. And again, these questions are from the perspective of the actual Canadian family that's doing the relocating, not us asking them. Okay, question number one. Now that I'm moving to the US, should I establish a trust? And if so, who do I make the trustee and powers of attorney? Okay, and there's more, but let's just leave it there. We'll get into some of the minutia afterwards. But let's start with that.
Sure, sure. So it sounds like an easy question, but it's kind of a complicated answer. Um, and of course, every answer to any question you ask a lawyer is it depends.
It
But
depends
uh,
exactly.
what I like to do is take a step first back and think about what is the basics of what we call a revocable living trust is, because that's usually they come here and they hear, well, everybody's got their stuff in a trust. Do I need to get one too? And so, in basic terms, a revocable living trust is an agreement, it's a contract, and it's by a trust maker. Sometimes you hear the terms settlor, grantor,
Yes.
trustor. I like to use trust maker. I like plain English. You make a trust, you're a trust maker. And the trust maker gives property to a trustee to hold and manage. And while the trust maker is alive, that's also them, right? Typically, they're also the trustee.
Right,
And
right.
the duty of that trustee is to hold and manage that property for the benefit of a beneficiary. And while someone is alive, that's also them. So it's a sort of a legal fiction in terms of how people own property during their lifetimes to make it easier on their loved ones and themselves at their incapacity and their passing. And so that is a fairly universal concept across the jurisdictions. And the most core concept to that is that the trustee is considered the owner. After that, that's where the jurisdictions go apart and get different, including between Canada and the US. Even though we're based from common law, we sprung from the UK.
Mhm.
Canada is much more aligned with the UK interpretation of trust than the US interpretation of trust. And so the first thing we want to look to if someone is moving to the US and thinking about establishing a trust is what is their citizenship or residency status? If you want to be the trustee of your trust, are you considered a US person? And so the definition under IS rules of a US person is basically a US citizen, a long term permanent resident or green card holder,
Mhm.
or a corporation. So certain visa statuses, while they give you legal residency in the US, they may not necessarily make you a US person unless you've got that long term permanent residency status.
A
And
hundred
so what
percent.
happens, it happens if you have a trustee who's not a US person, then that trust becomes a foreign trust under those IRS rules with
Right.
all sorts of additional complicated reporting requirements, possible taxation. So
Right.
typically people don't want those burdensome requirements or tax exposure.
Well, you know what?
Um,
Yeah, you just brought
mm,
something up because I was going to ask you, what the tax risks were for selecting a Canadian resident who isn't a U.S. citizen, but you made a really good point there. It's not just citizen, it's permanent resident. So you could, in theory, from what I'm hearing from you, you could be a green card holder, Canadian citizen, and be the trustee. Is that correct?
correct, correct,
If you're a
correct.
resident
As long,
if you're living in the U.S., correct?
correct, correct. You can be
What
the
about, I
trustee of
got
your
one
own
for
trust.
you. I got a
Yeah,
question. Okay, so we all know we're familiar with some of the different types of visas. I'm
yeah.
thinking right off the bat here, E2. I'm
Hmm.
familiar with that one because that was the one I used initially to get established here in the US. Is an E2 person fall under that category, or would they not qualify it to be a trustee based on the criteria of not trying to create a world of hurt, for lack of a better word?
Yeah, yeah. So during that initial period, not likely because the point of that visa is that there's supposed to be an intent to return to your place of origin, right? Now, of course, you can later extend that and translate that into a long time permanent visa, right? Long
Yeah,
time permanent
into a
resident
green card. Yeah, again, which is
into a
what,
green card. But
but
during that time before you get that green card, you are not considered a U.S. person.
and the same with H-1B.
Correct.
And obviously TN, that one's an obvious one, the TN. All right, Carolyn, you're just a fountain of knowledge, I swear. All right, so that's the key part of this. And I talk to clients about this, about, the importance of having a permanent resident to be the trustee, because otherwise you can create a lot of complications from a tax perspective. And
Correct.
but
And
that
yeah,
doesn't,
go
but
ahead.
it's different though for powers of attorney though. You could have a non-resident power of attorney because that is while you're still alive, and they're basically addressing your affairs like your finances, paying your bills, and making health decisions, right? So there's no issue there as far as I understand. Or I know ideally,
Correct.
I'm saying I have, I don't want to take your airtime from you here, but my views on powers of attorney have dramatically changed over the last decade. When I was back in Canada with my financial planning practice there, wealth management practice there, I would admittedly, tell the family, sure, have your close family members be your power of attorney because at the time it seemed like the right advice, but I'll say right now my attitude has changed on that, and I've mentioned it on the podcast more than once that you know spending the last 12 years in the United States has kind of jaded my perspective on that. And I would say, wherever you can get a third party trustee involved that is not, tied to the family is can. I've seen too many instances of elder abuse and
Hmm.
and just quite frankly, misappropriation of funds by even the closest family members. I'm talking,
Yeah,
next of kin, you know,
yeah.
grandchildren, nieces, nephews, daughters, sons, etc. So, um, anyway, I not to hop off on a tangent here, which I just did, but
No, yeah, I think that's a really relevant point because I agree with you with the potential of abuse for powers of
well,
attorney.
we hear so many
Um,
stories, my
yeah,
Lord.
yeah. Yeah, and financial institutions are also becoming more risk averse. A lot of times they won't accept them if they
Right.
haven't been updated recently. And then you get on the opposite end of the spectrum, you can get difficult positions. A lot of times we draft what's called springing powers of attorney, so they only become effective upon declaration of incapacity. And sometimes, and particularly an elderly person may present well to doctors, and we can't really get that sign off from the doctors. on that. So there's a lot of different issues with that. But when we talk about being a U.S. citizen or a green card holder, or that I referenced corporation. So a corporate trustee is also another person that you could have
Or
that can
even
protect,
like here
yeah,
in
or a
California,
professional fiduciary, right?
this is where I was going to go with this because
Yeah,
we moved down here 12 years ago. That's we don't have the deep, we're getting there, but we didn't come here with deep ties to the US. So when we
right.
established our family trust, we went that route of getting a professional fiduciary.
Yeah.
And basically, their role isn't just on the trustee side, also on the powers of attorneys as well. We basically, it seemed to be logical, and we have more of a complicated estate plan, but whatever it is, I just felt that it would be best to have somebody uh, unconnected to
Hmm.
take that responsibility on. Okay, Carolyn Bys, let's move on to the second question. Again, this is the three questions Canadians should ask before. Three questions, three estate planning questions Canadians should ask before relocating to the United States. Question number two: what are some of the alternatives to a trust if I'm looking to avoid probate? There we go.
Yeah,
Getting a
it's an
little
interesting
technical now, but
question.
away we
Yeah,
go.
yeah, yeah. So here's my pitch on this is that I always remind my clients that probate avoidance is not estate administration avoidance. So after you pass, the government still wants to protect your interests and, by the way, those of all of your creditors until your estate is settled. So that means there's an obligation to pay debts, file your taxes, settle any outstanding claims, and then distribute whatever's remaining to your designated heirs. So if your estate is insolvent, then your heirs aren't responsible for your debts. So, in theory, you can avoid probate by making sure accounts with beneficiary designations are updated, your IRAs, your brokerage accounts, your life insurance. You can even make your checking accounts payable on death. You can even have real estate in many US states that have a transfer on death deed. However, there's not a lot of contingency planning that can happen with beneficiary designations. What if your beneficiaries predecease you, or you don't update in time, or you can't because you're incapacitated? It doesn't necessarily go to your predeceased beneficiaries' heirs, but to the
Mhm.
remaining beneficiaries. And if none, then to your probate estate and settled by your will if you happen to have one. And if not, according to the intestate rules, which means the
Of the
rules
state, and we've
if
done
you
talk.
die, yeah,
Oh
yeah,
boy,
if you don't die, that it will.
if you
And
die
if
intestate
minors
in certain
inherit,
states,
yeah, yeah, it's in California too.
I know.
And and if minors inherit, it will also go to probate. And if you try to direct to an adult in charge of that minor instead, then the money is theirs, subject to all their debts, all their creditors. And for me, the big thing is if there are multiple heirs receiving money directly through these probate avoidance tools, who's going to be responsible for paying those debts, claims, and taxes? Now, if the estate is insolvent, they're not responsible. But if they get an inheritance, those governments, those creditors can come after them for their debts, claims, and taxes due from that decedent's estate. And if one person steps up to pay that, what is the process for them perhaps getting it from the rest of them? How are they going to go to court to make others pay their fair share? So I wouldn't put a revocable living trust entirely out of the picture. Consider ways to make it work for your situation. And the one you talked about as example is finding that US trustee, right? Including that corporate trustee or professional fiduciary. Even while you're alive. Um, and one thing that I did want to touch on too, although I'm not licensed to practice in Canada and I'm not giving Canadian advice, I do know enough about the broad strokes to know what the risks are and when to go ask Canadian Counsel for support. And one of those things is a lot of times people think, well, I'll just name a Canadian resident as my successor trustee,
Not a
right?
good idea, as we already
Not a
discussed.
good idea. Okay, yep, because not only that, it has implications in Canada too. So anytime the trust has a Canadian trustee, it can be viewed as a Canadian resident trust. And it sort of establishes the value at the time that it becomes a Canadian resident trust. And if your successor trustee, you think they'll only come into effect at your death, but they actually come into effect at your incapacity, and that incapacity is over a certain amount of time, um, and at your death, your heirs could be exposed to capital gains in Canada for that increase in value between the day it became a Canadian resident trust and the day you died. Um, so it's really important. In fact, I saw a client recently who did a DIY plan, named his brother as his successor trustee. He was a Canadian citizen and resident, and we quickly fixed that because that's a real issue. So it's not
You,
just for you as an individual, but when you're thinking about your broader families and successor trustees.
we had a unique case here recently that we're working on where the beneficiary of a trust was, well, actually, the the deceased was in US. The client was a US citizen living in Canada, in Ontario, Canada. And they were named as a co-trustee of this trust that the deceased assets went into. So after having discussions with a estate planning attorney, a couple CPAs, it was
Mm-hmm.
concluded that the client needed to resign.
Mm-hmm.
Now the options were, and again, I'm thinking, well, this person's never moving back to the US. They made it very clear to me, cut and dried. We're living in Canada forever. Married, we're staying here. So I said, well, why wouldn't the trustee then, who's the other family member, just forward the money to the client and we put it into a Canadian? Well, the attorney brought to my attention that apparently that would potentially leave the trustee in the US exposed legally if anything were to untoward happen to those proceeds in Canada. So the solution was resign as trustee. The other family
Mm-hmm.
member remains trustee. And for his share of the proceed, we've transferred into a custodial account.
Mm-hmm.
And we will convert probably over time to Canadian dollars because the client is a Canadian
Mm-hmm.
resident. So that was the workaround on that. But what you talked about, if he would have remained as the trustee, the implication that you talked about earlier, were being exposed to Canadian tax law, became
Mm-hmm.
the challenge more so than when you have a
Right.
usual situation with a US trust and a Canadian trustee. It was more the exposure in Canada that they were concerned about
Mm-hmm.
than it was in with the IRS.
Right.
So there
Right.
you go.
Right.
Just there you go. Perfect example. All right, Carolyn Bys. Let's go on to question 3. And again, Carolyn is joining us from Portland, Oregon. She's international. She's an estate planning attorney with a deep knowledge on international client cases. And really happy that you're here, Carolyn. So question number 3, and these are for the 3 questions Canadians, 3 estate planning questions Canadians should ask before relocating to the United States. Does it make a difference from an estate planning perspective if my move to the US is temporary or permanent? In other words, you can see a situation, I've seen them, where people have taken on, uh, they know they're coming down for maybe 5 years, 10 max, and then, but maybe we'll say 5 years. Like they know they're coming down for an extended, but they're not going to die there. Does that
Mm-hmm.
change the strategy? from an estate planning strategy?
So I'm going to give you a variation of my it depends answer
Yeah,
with
I
a
knew there was an
yes
it
and
depends.
no.
I knew the it depends was coming. That was a given.
Yes and no. Yes and no. So, first off, I think it's always important to bring up the estate. We have an estate tax treaty. Well, technically, the U.S. and Canada have an income tax treaty, but we've inserted some estate tax provisions in there. So, whether they are in the US or in Canada at their death and they're holding US assets, um, they uh, they can still get some of the benefits of the federal estate tax exemption. So right now at the US federal level, the estate tax exemption is 14 million per person. It's set to reduce next year.
I
We'll
am
see what
doubtful that it's
happens.
going to, by the, I don't know.
Correct, correct.
I think we're going to get that one
And
extended.
more. Yeah, or and possibly
But you're
more.
right. As of today, as of now,
Yeah,
until
yeah.
further
But
notice,
yeah, so but let's just say 14 million per person because that's what it is right now. So if 50% of your worldwide assets were located in the US, you basically get a percentage of that estate tax, US federal estate tax exemption. So that means you basically get a $7 million exemption for things in Canada. And it wouldn't matter if you resided in Canada or the US. And it also allows some marital deductions also for assets left to a non-US citizen spouse, again, whether you live here or in Canada. So that's one piece that probably doesn't change much if it's temporary or permanent. Um, the second, but the no says is that if you have that revocable living trust, and let's say you're on the green card. I've got quite a few clients in my pipeline from different countries giving up their green cards. Um, so with that, and returning to Canada, if you had a revocable living trust and you were your trustee of your trust here in the US, remember I said before, if you move up to Canada as a trustee, now it's going to be considered a Canadian resident trustee and have all sorts of implications for
yes.
tax filings, for exposure to capital gains, all those sorts of things. So, one of the things that I do with a lot of my clients is not dissimilar for what I do with what you call your sort of vanilla US estate plan, is oftentimes I tell clients make your spouse the primary beneficiary on your IRAs, your investment accounts,
Yes, for sure.
and name your trust as the secondary beneficiary.
Interesting.
And so that way you're kind of getting the best of all the worlds. You're at your during lifetime, your trust isn't owning anything, but you're able to use it to bypass probate at your passing. And to make sure, and it's got all those contingencies in place, right?
Would that
So if
be the
beneficiaries
case?
predeceased you.
Would that still be the case if you have adult children, Carolyn? In other words, would you still, because I,
Um, it just depends upon again that trustee status, right? So if you can name successor trustees in the US, and I think there's less risk of naming successor trustees at your passing who are Canadian residents.
I wasn't thinking of the
Because
trustee, I was thinking of the
yeah,
beneficiaries of
sorry.
the IRA.
Oh,
Because the benefit,
yeah,
so my question is, if you have an IRA, obviously, like you say, you always make the spouse the
yeah,
primary
primary.
beneficiary, and if you have the option of adding in you know, a secondary beneficiary, I guess the question I would ask is if you have children, adult children, residents of the US, for example, you could make them
Hmm.
the beneficiary as opposed to the trust. Your thoughts?
Correct, but yeah, but I feel like the trust has a little bit more layers of protections, right? So it's the trust
Interesting.
is sort of the foolproof way. I mean, people certainly do that, but it kind of goes back to those issues around what happens if your kids predecease you and you're already incapacitated and can't update those beneficiary designations. Then that won't go to their heirs, it'll go to the other kids, and then those kids are making a gift, even if they want to share it. If
So,
there's taxes and expenses that need to be done in the US, what if you have kids who don't get along? Who's going to end up paying those? And how do you kind of fight those out? Whereas if you put everything through the trust, it all gets administered. Remember, probate avoidance is not estate administration avoidance.
right.
So I feel like the trust is the best vehicle to ensure that everything is tied up, all those last taxes are paid, no one bears an inordinate responsibility for doing that, particularly if you have any potential family dynamics that might
I
indicate
know, and that
people want
never
to
happens,
push
right?
each other.
Yeah, right.
Yeah, yeah.
All right. Well, that's an interesting. So, if the does the trustee have the ability after the fact to elect to disperse the proceeds in the IRA to an inherited IRA to both, say you have two children, two adult
Uh-huh.
daughter, son, 21 years older, and the proceeds that are the IRA is the benefit, the trust is the beneficiary of the IRA, but the beneficiaries can then receive 50% of the IRA, and it goes into an inherited IRA so that the beneficiaries will then have 10 years to draw down those proceeds. The trustee will
Correct,
have
correct.
that. The trustee will still have that ability.
Correct. Correct. Absolutely. And we write trust to ensure that under the new Secure 2.0 rules, that it's what's called a see-through trust,
Right.
so that the individual beneficiaries still get that same benefit, that 10-year withdrawal period, as
Yes.
if they had inherited directly. Yes, absolutely.
We could go down a rabbit hole on this one even further, but I realize that
Yeah,
we're coming up to it. Before I do want to let you get out of here, but I do have, before we wrap up, I have one additional question. This is from me.
sure.
Uh, in your opinion, are there any general rules of thumbs in regards to unwinding a revocable trust when relocating back to Canada?
Yeah,
Uh,
that's a great question. Yeah,
okay, I may actually, depending on I may actually
sure.
have one more, but if you could give me your
Sure.
thoughts on that one.
Yeah, so that's a great question. I've got some clients recently. He's a dual U.S. citizen, Canadian. She's only a U.S. citizen. They're just starting to set up their revocable living trust here, and um, and they're contemplating moving to Canada. They're still in the very beginning stages of where do we want to retire, and thinking that through. And so I've said, let's start here. My advice is always that an estate plan is never written in stone,
Written in
particularly with
sand.
revocable,
Yeah.
right? Particularly with revocable living trust, the name itself says we can change it a whole bunch of times. But generally, what happens is that I'll want them to come back to me, and then we'll take a look when they get a little bit closer to making that decision. It's still maybe a 5-year plan, but I've shown them kind of what their exposure is to estate taxes and other taxes up there. So they've got that at least under their belt. And at that point, we'll take a look at what their goals are, what their assets are, and kind of what their legacy plans are. And then we'll sort of sit down and figure out what the best strategy is. And a lot of times it may not, like I said, may not be necessarily unwinding that trust, but it may be retitling assets, right? So make that trust, as I said, the sort of either primary or secondary beneficiary upon their passing. And that's actually a lot easier, a lot simpler, and inexpensive to do than sort of doing away with it all. And that way it makes, again, that estate administration process much easier on their loved ones than having that stuff go through probate. Because so many people, even though they want to leave this country with their physical bodies, they want to keep their money here.
Right.
Um,
Exactly.
so we want to
And not
we
just for
want to find
Canadians.
ways.
These are people from other parts of the world too.
Oh yeah, absolutely, absolutely. They don't want to necessarily live here anymore, but they want their money too. Um, so, we need to find ways to make it as easy as possible for those international families.
Yeah, there's for folks who've already lived here, I think not just for Canadians, but also, like I mentioned earlier, for people around the world that maybe have lived here for many years and maybe, for family reasons, not financial reasons, that they want to go back to, their homeland. And so,
Right.
they've accumulated wealth in an IRA, they've accumulated wealth in a revocable trust. And, in some instances that you can look at some good reasons why, depending on their citizenship status, why it would make sense to keep that trust active, even from a tax
Mm-hmm.
reporting perspective, because, if you have to maintain ties to the US and ties to the IRS in particular, then having your liquid assets in a trust in the US will help you avoid some of the PFIC, the passive foreign investment corporation
Mm-hmm.
issues that you can be subject to. We talk about always usually in my sort of orbit of, the Canadian who has relocated to the US and they have Canadian dollar accounts. It also applies to Americans, citizens living in Canada, that if they have Canadian dollar investments, they have to be careful with, the
Mm-hmm.
exposure to passive foreign investment corporations, because they are taxed at the highest possible tax rate, and
Mm-hmm.
it encompasses, not all, but most mutual funds, most ETFs, exchange traded funds. And in Canada, they have, it's pretty much the equivalent of a variable annuity. Here in the United States is the segregated funds, which are mutual funds with an
Mm-hmm.
insurance wrapper. The IRS views all of those as passive foreign investment corporations. And if you are either living in Canada as a US taxpayer, or a Canadian living in the US, and you hold these types of accounts, whether they're custodied in Canada or here in the US, there's some additional reporting, and that reporting, I can tell you, is not getting any cheaper. Most CPAs I talk to, in order to avoid that high tax rate, there's a form called a qualified election form, or a QEF. They typically are now charged like $500 per investment account to fill out this form. So I will tell you, in my experience of working in the investment world, it's not uncommon to have 15 or 20 PFICs in an investment account. So
Mm-hmm.
do the math, right? You pay
Right.
$10,000 just, I mean, it's just,
Right. Wow.
so
Yeah.
again, that's why you want to be very careful. And that's why I was thinking, for folks that are leaving the country, that they may want to keep their trusts intact
Mm-hmm.
and avoid those types of issues. Great conversation. One thing, every time I speak with you, Carolyn, I always learn something new, and I really appreciate you making time for making yourself available. You know, for the folks watching on our website, they can see your contact information on the screen, easy to read. But we have a lot of folks listening in on Apple, on Spotify, they may be driving in their cars. They have no idea how to get a hold of you. So, what is the best way to reach you?
Yeah, best way is you can reach me at my website. It's easy, www.goodwillandtrust.com, or you can reach me at my email, Carolyn, right as you can see the spelling there, Carolyn at goodwillandtrust.com.
Perfect.
Happy to take your questions.
Yeah, by all means, I can suspect that the folks listening in may be curious. So I really appreciate your time, and thanks again, Carolyn, for joining us today. Carolyn Bys is an attorney at Portland, Oregon, based Goodwill Trust Estate Planning Law, and was an awesome guest today. Thank you, Carolyn.
Thank you, Wayne. My pleasure to be here.
I look forward to bringing you the Three Questions podcast, and I hope you find them educational and informative. please consider liking this video and subscribing to our podcast and YouTube channels. And to receive notification of when our latest episodes have been posted, please click on the notifications bell. Lastly, to schedule an online Zoom consultation with me to discuss your wealth management needs, please click on the link in the description box below, www.onecapital.com/meet with Wayne. Thank you, and we will see you soon.